Have you ever had the misfortune of having your child be subject to disciplinary action for something they may or may not have done at school, and then that disciplinary action leads to a possible expulsion, and then you're sitting there wondering, hey, what do I do now? My child receives special education services. Shouldn't they be subject to some sort of protections? Well, the answer is yes, and this video is for you. Ladies and gentlemen, boys and girls, YouTube, thank you so much for coming back. My name is Eli. I am the lawyer guy, and today we are going to be talking about school discipline, expulsions, something that every parent fears and is never a good thing for any student and parent to have to go through. It's probably one of the most difficult situations to have to navigate as a parent. And when we're talking about children that are qualified to receive special education services or should be, then we're talking about an even more in-depth analysis and even more laws which apply. And that's what we're going to be talking about today. Now, where we're going to start is a little bit of a history lesson. Prior to 2004, any student that was subject to disciplinary action based on a school-based incident was subject to disciplinary procedures that were laid out in the Education Code, namely certain notification procedures, an expulsion hearing, and a possible expulsion. That applied to everybody all across the board. Now, what had happened was through the course of having the IDEA in place for quite some time and the reauthorization in 2004, President Bush put into place some protections for special education students with regard to discipline. And what that is called is a manifestation determination, or an MD. And that has an exploration in it to see whether or not the behavior in question was a manifestation of the child's disability. Now, that was something that wasn't in place before at all, and this has to occur before any disciplinary action can take place. So the disciplinary violation takes place, then the manifestation determination has to take place. Only then, if they determine that it's not a manifestation, can they move forward with disciplinary action. Now, let's unpack that a little bit and kind of go through the process here. Now, what we're looking at is two things. Number one, a change of placement. Now, what we're looking for here is a removal from school of 10 days or more. Now, that can be a couple of different ways. Number one is if the school is purporting to expel your child. That is automatically a change of placement and comports with the 10-day rule. But number two is a series of suspension or disciplinary violation which removes them for a total of 10 days. If that occurs, then that is also considered a change of placement, and then you have to hold the manifestation determination. Now, the manifestation determination is an IEP meeting, but not an IEP meeting in the traditional sense. It is a very specific IEP meeting. And what we'll be looking for is whether or not this behavior, the behavior in question that led to the disciplinary violation, is a manifestation of this child's disability such that they cannot be subject to formal disciplinary action. Now, that involves two things. One, was the conduct in question caused by or did it have a substantial relationship to their disability? And number two, was their IEP in place such that all services were in place at the time of the disciplinary violation? And this is an OR standard. These are what we're looking for. If either of these two things apply, then it is a manifestation. The school district cannot expel your child, and they have to do a functional behavior assessment and create a behavior intervention plan to try to address the behavior in question more appropriately going forward. However, if it's found not to be a manifestation of their disability, then the regular disciplinary procedures apply. You move forward to a formal expulsion hearing, and then that procedure takes place. We'll talk a little bit about that a little bit later on in this video. So, what are we going to be looking for in terms of the manifestation determination IEP? Well, number one, it's going to be the same as another IEP, which is that all people that need to be there are there. Anybody that's providing your child with services, anybody that can lend themselves to speak to your child's disability and the nuances of your child's disability, you need to be there. If their child is a certain age or contribute, they should probably be there as well. And we're going to be looking for, again, somebody that can make decisions for the district. So if you don't have somebody there that can make decisions to say, yes, we're going to move forward, or no, we're not going to move forward, then that's going to be inappropriate. You need to have all of those pertinent parties there in order for this to be a valid IEP. Number two, you're going to need to have all of the students' pertinent educational records. This is where a lot of school districts go wrong with the manifestation determination IEP. They bring the student's most recent IEP document, and that's it. They just sit down and say, look, we're going to look at this. This says that they're qualified under this, and I don't think that that's a manifestation of this, and then that's going to be it. That is not the exploration. It says all available pertinent records. So the school district should have your child's cumulative school file there, and they should have all their records available to be able to explore whether or not this behavior is in fact a manifestation of their disability. And their disability is not their disability classification. It is their specific manifestation of that disability. An example is autism. Autism can display itself in any number of ways in any number of children. It's very individualized. So to say, well, this is not typical of autism, that's not going to be sufficient. How does Johnny display his autism? How does autism work in Johnny? And that is the exploration that we need to make. Is that consistent with his display of autism? And that is another aspect of the manifestation determination. Are they looking at your kid's classification, but are they also looking at possible alternate classifications that could apply based on the information that they have? If your child is qualified under specific learning disability but has numerous problematic behaviors, then we need to be looking at, okay, he's qualified under SLD, but his behavior is indicating that his disability might be manifesting itself in a different manner, such that we need to look at possible alternates, not just the SLD classification. And another thing is to do a full evaluation. Now, this is not necessarily the case in every single manifestation determination, but a lot of times when you look at your child's records, you're saying, look, it's been 3, 4, 5, 6 years since you guys did an evaluation. I don't feel that you have a good grasp on what his manifestation is of his disability, such that you guys need to do a full evaluation before we can do this and make sure that we have a good grasp on what his disability classification is and what the manifestations are of that disability, so that we make the right decision here. So that full evaluation could be a very good piece and a part of that, and that might be something that you want to request during the course of that meeting. If you feel like, oh, the district doesn't really have a good grasp on this, and I think they need more information. Now, another thing you might run into is the Interim Alternative Educational Setting, or the IAES. Districts have discretion under certain circumstances to remove your child for 45 days to an interim alternative educational setting. And those situations have to do with possession or sale of a controlled substance, infliction of serious bodily injury, or bringing a weapon to school. Under those circumstances, the district can say, look, this person presents a continuing threat to the health and safety of themselves or others, such that we need to put them into this placement for 45 days while we're working this whole thing out. Even though they're removing them, though, the placement that they're put in still has to be able to provide them with a free and appropriate public education. It still has to be able to implement their IEP. Now, this is litigated a lot, the appropriateness of the IAES, and it is usually a loser for parents. Courts will give districts a very wide latitude in terms of what an appropriate 45-day placement is, but it has to be one of those three situations in order for them to be able to appropriately put the child into the 45-day placement. They can't be accused of, property defacement and then say, oh, well, they're a serious threat, we got to move them. That's not going to work. It's only those three situations. Now, what if a child is not qualified to receive special education services, they commit a disciplinary violation, they're going forward towards expulsion, but you're saying as a parent, hey, I think my child should be qualified for special education services, and I've told you guys that before. So, what are we going to do about that aspect of it? Well, the law does provide protections for them as well. The situation is called a basis of knowledge. Now, that is a short way of saying that the district had a basis of knowledge that this child was a child with a disability, such that they should be given the protections of a manifestation determination. Now, the law states three specific times when basis of knowledge is going to apply. Number one is the parent makes a written request for a special education assessment prior to the time of the disciplinary violation. Number two is the parent in writing has stated to teachers or administrators that this child does have either academic or behavioral concerns that could rise to the level of special education, so they've been made aware. And number 3 is that a teacher has made an administrator aware that this student is exhibiting a pattern of behavior that is similar to the behaviors that are the reason for the disciplinary violation. Now, if any of those 3 things apply, you have a basis of knowledge such that you can file a complaint and say, you guys had a basis of knowledge, you can't expel my child now, you have to do this evaluation. And the school district will be bound to do this evaluation in an expedited manner to be able to come back, say, do they qualify for special education? And if they do, we have to do a manifestation determination before we can move forward with any disciplinary violations. And honestly, you guys, as a pro tip, what I would suggest is if your child is struggling with a pattern of behaviors or academic difficulties and they're put up for a disciplinary violation, I would suggest that you make a direct written request for special education assessment right away and give it to the district and say, look, I think that he qualify, and you're going to need to do that expedited assessment. It'll give you an opportunity to have that exploration done and maybe give them that additional level of protection. At the very least, it'll give you a little bit of time to maybe determine whether or not you need an advocate or an attorney to represent you through the disciplinary violation or with a possible denial of a free and appropriate public education for your child. If you do make that request, all disciplinary action has to stop and be abated. The district will have to do that expedited assessment before they can move forward with any kind of disciplinary violation. So again, let's go through what could make a faulty manifestation determination. Number 1, they don't have any records there or they only have a few records there. Number 2, not everybody is there that needs to be there. Number 3, they don't make an appropriate examination as to not only your child's disability classification, but any alternate classifications that there might be. And number 4 is they just mess up the analysis. They don't get to whether this had a substantial relationship or caused the behavior in question, or they don't examine if the IEP was in full effect. You know, you can say, oh, you know, little Johnny is supposed to be getting counseling once a week and he hasn't had counseling for 6 months. So the IEP wasn't in place, so you can't move forward. This is a manifestation. And the district doesn't have any answer to that, and they don't address that. That makes a faulty manifestation determination IEP. Any of those things can invalidate your manifestation determination, such that you can file a complaint and come back and say, look, you need to rescind that expulsion and we need to fix this. So what's our plan of action here? What are we looking to do? You know, Eli, what do you suggest? Number 1, and I'm going to get on my soapbox here for a minute, is avoid expulsion hearing at all costs. Expulsion hearings are farcical, meaning they're ridiculous. The California Education Codes provides districts with the latitude to have their own employees hear your expulsion hearing. They just can't be from the same site that your student is at. So what they'll do is they'll take 3 district employees from alternate locations and have them hear your expulsion hearing. They are not experts in education law. They are not in any way disconnected from the district. They are directly affiliated with and paid by a party in this litigation. What? Namely the district, the plaintiff. And the plaintiff has its own employees hearing your expulsion hearing. So it's ridiculous. And honestly, guys, I have been to a number of expulsion hearings that I've had my clients to where there is absolutely no proof that they did what they were accused of. There's absolutely nothing substantial other than a person saying that they did it. And we put on a great case with witnesses and documentary evidence, and we cross-examine everybody, and it's an amazing case. And then 3 days later, I get a letter with a single paragraph saying, your client has been expelled, here's the date of the school board meeting, school board rubber stamps it, and then it just moves along. They have no evidentiary awareness. They just don't care. They're going to have their school district employees find that this person did what they did, and they're going to expel them. That will happen. So we want to avoid expulsion hearing at all costs, if we can. Number 2 is, again, we want to make sure that all the parties are there and that we're reviewing all of these educational records. If you see that the educational records aren't there, you say, look, guys, we need to table this meeting until we have a chance to have everything that needs to be here. Number 3, we need to request reevaluation. If you don't have a recent evaluation of your child, you should say, look, we need to reevaluate and make sure that we're getting their disability classification right so that we can make this determination correctly. Bring outside professionals, guys. If your child has mental health services, therapy, anything like that, ABA, bring them in. Bring them in to say, look, this is what this child's disability looks like, and it is very consistent with what you're accusing them of. Have that professional input there if it helps support what it is that you're trying to say. And last, no 5-minute meetings, guys. No in and out, no quick meetings. This is a very intricate and important decision, and it needs to be taken that way. I can't tell you how many clients I've had that have said, look, yeah, we just got out of our manifestation. It took 15 minutes. And, they looked at his IEP, said that he was SLD, and said, this is obviously not a manifestation. So we're going to go ahead and move forward with expulsion. That is not at all acceptable. They need to be sitting down. Everybody needs to be giving input. His teachers need to be giving input. Related services. How is this child's behavior? What does it look like? Is it consistent with what we're seeing in this disciplinary incident? Outside professionals, assessments, records, you, the kid. Everybody should be giving this input consistent with the analysis. Is it caused by, or does it have a direct and substantial relationship to their disability? Is their disability classification right? This is a long analysis, guys, and it needs to be treated that way. And it's going to be up to you. I'm going to tell you this, guys. It's few and far between when I get a manifestation determination document and I look at it and say, it's pretty good. They actually did a really good job here. Most of the time, it's extremely deficient. And the recounting that I'm getting from my clients is it's quick and it's messy and, whatever. We're good. Expulsion. And you need to be the one that says, look, this is what we need to do today, guys. This is what we need to be looking at. These are the people we need to be talking to. And we need to get through this analysis slowly and methodically because this is my child and I'm not going to accept them being put up for expulsion inappropriately. So let's make sure we get this right the first time, okay? No 5-minute meetings. Make sure it takes as long as it needs to take. If they need to call a break, have another meeting, do it. Be that zealous advocate for your child, guys. Be that voice for them and make sure that this is done appropriately and make sure you can avoid that expulsion hearing. Because let me tell you, once it gets that far, there's a very good chance it's going all the way. Okay, so that's it. That's discipline in kind of a nutshell. For special education students, regular education students, you're going to be subject to regular disciplinary policies. You can find them in the education code. Usually it's just a big long line of disciplinary policies and notification and things of that nature. So if you guys have any questions or concerns about this, go ahead and put them down there in the comments. Please hit the like button and subscribe to our channel for more information, for more content. Please give us any suggestions about how we can make the channel better, or if you'd like to hear a certain topic, and I would love to give that to you guys, okay? Thanks again for watching, and I hope you guys have a great weekend. Thanks.